wish.
Hello, everyone. Thank you so much for joining us here at CPAacademy.org. We are so excited to have Justin back from Calyx. I'll be handing it over in just one moment for Challenging 280E. Before I do, we're going to do a few housekeeping items. Check in with you, the audience. Make sure everything is working for you. Make sure you know how to use that Q&A pane to ask questions during the session. I'll let you know about your handout, and of course, we'll let you know about your CVE. So let's get started. If you don't mind drawing your attention over to that Q&A pane, say hello. Let us know what brings you here today. Have you attended any of Justin's other courses? What are you hoping to get out of today's session? We'd love to learn a little bit about you. So please feel free to post that now in the Q&A. If you have questions during the session, we welcome questions. We'll try and make time at the end for any Q&A. So please ask your questions as the session goes along. And if you have any technical issues, I'll be on to help with those. There is a handout available for this course. It was available in your account at cpaacademy.org, and it's also in that handouts pane. You can download that now and follow along. This is a 1.5 CPE course. In order to get that credit, you need to do two things: attend this full session and respond to the attendance checks. Those attendance checks will be launched at random intervals. You just need to respond to, I believe it's 5 of them during the session. You'll be good to go. We'll do our best to get your CPE processed a little later today, but you should see it in your account by tomorrow. We will also be recording the session. We'll make that archive link available to you later today as well. So let me check in with our audience. People coming in, let me know if things are working well. Looking to gain new information regarding this industry. Perfect. People saying that the audio is coming in. All right. Looks like things are going well. That's my cue to step aside. Justin, thank you so much for being here today. Our audience is ready, and the floor is yours.
Okay. My name is Justin Botillier, CEO of Calyx CPA, based out of Medford, Oregon. I didn't want to say it, but it's only 8 days until tax season, and it's 2 p.m. here, which is my nap time. So I'm looking a little haggard myself. And if you're here, I appreciate it. I know it's an extremely busy time, but I didn't feel like this information can wait. I want to get it out to the professionals, the cannabis professionals that are working with the cannabis industry, and hopefully get a little bit of momentum, trying to put the cap on this 280E business. I was very fortunate. I'm very fortunate to be able to present with you today. The organizers of CPE Academy reached out. I happened to be in the right place at the right time. Oregon, which has a licensed psilocybin regulated program here, and of course I was asked to talk about psychedelics and psilocybin, and then of course 280E, because psilocybin is a Schedule I substance. And that course went really well. I think I got an A. I was told I got an A for my presentation. So, and now I got invited back. I spoke on this briefly in another webinar. I wasn't as attuned to the information as I am now. I don't even remember if the IRS had actually answered the opening brief, but I have spoke on this topic a few times because we've been in the cannabis industry specializing for about 10 years. In 2016, I sold my regular general practice and I went all into cannabis because I realized that it's not a subject that you dabble in. It's something that needs your attention, especially if you're advocating for your clients, if you're trying to mitigate 280E. In those days, we were focused on 471A. Then after the Tax Cuts and Jobs Act passed, we turned to 471C, and we used that very aggressively, very successfully, getting our clients' liabilities down to near legal levels. There was drama with the regulation. The IRS tried to put a wet blanket on 471C. I have since found out that the IRS has not been challenging it, 471C, and right now people are starting to finally warm up to it. A little bit too late because we're on to bigger and better things, but 471C is still a very good good code section to use to mitigate 280E, and it's frankly pretty conservative from what I can tell. I wanted to get this message out then, but there's already been a lot of people in the cannabis industry presenting to the accountants and whatnot. So I'm really happy to finally get a spot to do this, and none too soon. Okay, so the things that I'd like to accomplish with this continuing education is to present the arguments in the New Mexico Top Organics tax court case, authored by Nathaniel Pollock, who's a very talented attorney. I will talk about him a little bit more. Then, I think a month ago, maybe 3 weeks ago, maybe a month ago, the IRS responded to that opening brief, called a answering brief. That's what it's called. Now, it's important to know ahead of time that that's not the tax court or the judge that responded. It was the IRS's response to Nathaniel's arguments. Okay, so it's not the law. It's not concluded. This is still a courtroom drama happening right now. Then I wanted to, the main crux of the whole thing is, like, do we have, and I'm going to talk about this, do we have a reasonable basis for not reducing deductions and paying tax on phantom income ahead of rescheduling? So that is a big, big question. That's a question that I get asked a lot. We have been not reducing deductions ahead of rescheduling for a couple of years now. We're on our third year of challenging 280E and not having our clients pay tax on phantom income. And we have been amending returns and whatnot. And then so this court case was great timing because it's using the exact same arguments that we were using before and presenting them in front of the court. And it's good to know that the IRS didn't take it to court. This was taken to them. So whether or not the IRS would have wanted to debate this in court, I'm not sure, but Nathaniel and team New Mexico Top Organics took it to them. And I'm sure I'll have more information on all of that. And then I have some answers for some commonly asked questions of us who have been doing this. Like what's the fallout, for example? I'll get to that. And then if we have time, hopefully I'll be able to answer questions that have been presented here today. Okay, so let's get going here because we have a lot. I've got 40, you may see it, I don't know, there's 46 slides, so it's a lot. It's not a time to review what 280E is. Listen to the webinar, try to remember it, download the Q&A, or not the Q&A, the handouts, and go through it, go research it, and then come back to it, because this is definitely like a 400 level class or 500 graduate. It's like a graduate level class, if you ask me. It is good to revisit what a Schedule 1 and 2 substance are, the criteria under the Controlled Substances Act, because this is like the crux of the argument. And Schedule 1 is considered, has a high potential for abuse, addiction. It's highly addictive. They say that these substances are highly dangerous and they have no medical benefit. That's a Schedule 1 substance. No, and it's highly dangerous under the supervision, even while under supervision. Schedule 2 is highly abuse or highly addictive, has some medical benefits and severe psychological and physical dependence. So it's highly addictive. So the Schedule 1 substance are some substances like heroin. And then to my chagrin and many other people, psychedelics and cannabis are also in a Schedule 1 substance. Obviously, heroin is a lot more scary than cannabis, but yet there it remains. Schedule 2 is cocaine, methamphetamine, Oxycontin, fentanyl, obviously more dangerous, more addictive than cannabis, but yet cannabis still is considered a Schedule 1 substance. And we're going to get to debate that a little bit as we move through here. The court case, of course, is New Mexico Top Organics versus Commissioner, sponsored by New Mexico Top Organics in New Mexico, of course, represented by Nathaniel Pollock. And now this was originally started out as an audit. The IRS audited New Mexico Top Organics back in 2017, 2018, 2019. Nathaniel, they took it to court, or they didn't take it to court, but they argued it. I think they took it to court. They won their other disallowed expenses, but they didn't get to not pay tax on their 280E deductions. And so then now they're proactively taking this to court, suing for their money back, essentially. And it actually may be that, yeah, that's what's happening. I apologize. I don't know I'm not an attorney. I have to preface this. I'm not an attorney. So, just be patient with me. But I am now an enthusiast of this stuff because it's so interesting. And so in the corner of New Mexico Top Organics, in our corner, we've got Nathaniel Pollock, who is working at South Bank since 2023. And before that, he was in the DOJ, the U.S. Department of Justice, for 17 years, serving as a senior level attorney in the tax division appellate section. Now, I don't know what the tax division appellate section actually means, but I'm assuming it has something to do with taxes, and he's got the experience, and it's probably him, working with the IRS or whatnot. I didn't ask him specifically what that meant, but it feels like 17 years working on the dark side. No, not on the dark side, but he has now come to advocate for cannabis, and none too soon for that. So his arguments, so what they are presenting in this opening brief, there are 3 arguments. 2 of them are, I would say, consider alternative. I don't think he says that. Maybe it does say it in that brief, but the alternative arguments have to do with the fact that the government has stopped funding enforcement of cannabis in states that have their own regulation, which he's saying, well, that is kind of a signal that the federal government actually doesn't care that cannabis is being grown and produced and trafficked, quote unquote, trafficked there in those states. The other argument is more of a constitutional argument. It goes back to Gonzalez versus Reich. There was a court case in which the taxpayer was suing that the Controlled Substances Act doesn't apply to our state because we are strictly intrastate commerce. We can't go across state lines, and therefore you, the federal government, really only have the constitutional ability to enforce when it goes across state lines, interstate commerce, and that is a constitutional thing. But the Supreme Court at that time said, nope. We're very much a federalist perspective. Like, how are we supposed to enforce the drug laws if we had to enforce them on a state by state basis? So that's ridiculous. But there was some dissenters, Clarence Thomas, and another Supreme Court said, hey, no, that argument has merit. And of course, they're more conservative. Fast forward today, we've got a Supreme Court full of conservative court judges. And they even overturned Roe versus Wade, signaling a states' rights perspective, very likely states' rights. So Canna Provisions, there's this other cannabis business called Canna Provisions. It went to and has been slowly moving up the district courts, up to the Supreme Court, to argue that the application of the Controlled Substances Act on these states is unconstitutional. Things have changed. Like back in 2005, when Gonzalez versus Reich came out, there was only a few states that had medical programs, and now most of the U.S. has some sort of program. I think there's only like 3 states that don't have medical or have even any policy whatsoever. Okay, but those are like separate, and I'll tell you how the IRS responded to those, which is kind of interesting. But the primary argument is the meaning of Schedule 1 or Schedule 2. So if you look at the tax code itself, it says, okay, it's the tax code itself. It doesn't say that 280E applies to businesses trafficking in substances that are classified or listed on as a Schedule 1 or Schedule 2 substance. It says that 280E applies to businesses trafficking in substances that fit the meaning of a Schedule I, Schedule II substance of the Controlled Substances Act. So we've really latched on to this within the meaning, which is a very important designation, and I'll tell you why and why it has enough merit to take it to tax court. Okay, so here's the code. I got ahead of myself a little bit. You can see that it says here, if such trade or businesses or activities which comprise such trade or business consists of trafficking in controlled substances within the meaning of a Schedule I and II of the Controlled Substances Act. Okay, so that's where we're kind of like saying, listen, there's statutory language that supports the fact that cannabis may not fit the criteria of a Schedule I or Schedule II substance, and therefore 280E doesn't apply anymore. Okay, so then in 2023, Biden, he said, hey, let's look at cannabis. Let's consider finally starting the rescheduling process, HHS. Let's go through the steps. And this is all laid out in the Controlled Substances Act. Like, there's steps for rescheduling and administrative processes and whatnot. And the first thing they do is they ask the HHS, well, what is your opinion about cannabis? And so they went back, and it's almost as if they had it in waiting already. The FDA wrote a 250-page paper that was also looked at by the National Institute on Drug Abuse, and then the HHS wrote this letter. And you can find this letter. Oh, I do need to let you know that you can find these. First of all, the opening brief is available. There's a link, view case on Dawson USA Court. All the briefs are there. So you can look at these for yourself. And then if you want to look at the 280E, the full language of 280E is there. It's on the link. And then now we've got this. We've got the HHS recommendation letter on the DEA website. Hopefully they don't take it down. But anyway, so we got this letter backed by a 250-page paper from the FDA, conclusively saying that cannabis doesn't fit the criteria of a Schedule I or Schedule II substance, that is solidly a Schedule III substance. So here we go, National Institute. This is what I just got done saying. The official quote, marijuana meets the findings of the control in Schedule III by the Secretary of Health. It wrote this formal recommendation. The HH letter to the DEA officially recommends moving cannabis to Schedule III. And then we got notice of proposal rulemaking. Merrick Garland, Attorney General, substantial evidence that marijuana does not warrant control under Schedule I. So this was back in 2024. And we had actually been, because of the reasonable basis rules, which I'll go over, the can provision argument itself was going up the district ladder, and we were using that to amend returns and whatnot, and it has since stalled. It's not that it has been turned down. It's just that the Supreme Court chose not to see it. Okay, not to look at it. This fortunately kind of overlapped that, and now we've been looking at this for quite some time before this recommendation. So, or at the time of the recommendation. Okay, so what are the arguments? Like, what about within the meaning? Why are we saying, besides the fact that it clearly states within the meaning? And first of all, there's some debate on whether or not what Congress meant by within the meaning, and maybe they meant listed on. Okay, so Nathaniel's saying. So other people are saying, well, Congress meant classified as, obviously. And then he's like, but no. And it doesn't really matter, because if you look at this court case, Varian MedSys Inc. and Subsidiaries versus Commissioner, the courts, the judge concluded the courts must presume that a legislature says in a statute what it means and means in a statute what it says and must, quote, enforce plain statutory text according to its terms, end quote. So this suggests the language Congress chose within the meaning of should be interpreted based on the actual definitions provided in the Controlled Substances Act, not merely on administrative classifications that may no longer fit those definitions. So that's kind of a pretty big argument. And he also goes into saying, well, maybe this was intentional by Congress. Maybe what they were doing is they wanted within the meaning, because what if there was substances that are classified as a Schedule 3, 4, or 5 substance that actually haven't made it to Schedule 1 or Schedule 2, but are highly addictive, highly dangerous, and have no medical benefits? What if they got on there on those, and then now we want to move it? Because I think fentanyl at some place it was like a Schedule 3, and then they moved it to a Schedule 2 because they realized what was destroying America, essentially. So then it got moved. Now, fentanyl is legal, so therefore 280E doesn't apply because it's still legal. And of course, 280 applies to illegal trafficking. But what Nathaniel is proposing is that Congress had left it open for substances that met the criteria of a Schedule 1 substance or Schedule 2 substance, but had yet not been moved, or so now we're kind of reverse engineering that. So that was one of Nathaniel's perspectives on that. And then the other thing is, like, the tax code uses, and the Controlled Substances Act uses, listed on and listed in to refer to lists a lot in the tax code. And so why would, if they wanted to have if they wanted 280E to apply to substances that are classified as, why didn't they just say classified as or listed on? Why did they use within the meaning of? And so then he moves on and he talks about, well, the tax code does use within the meaning of, and he gives 2 examples, and he may have given more, but I'm limited in the time and the work that I have to put into this. But there was 2 specific examples where it was talking about the child tax credit uses a percentage of the taxpayer's earned in, quote, the taxpayer's earned income, and you guys all know what I'm talking about here, within the meaning of a schedule, a section 20 or 32. And that section is what defines earned income. Okay, so what he's saying is that within the meaning refers to the definition of what earned income is. It's a definition. And then he also talks about married, and then it, quote, and then qualified the word with, so they used married, and then they said within the meaning of section 7703, which is now defining what married means, what it is, what married is. So that's an important distinction there. And you're going to see what the IRS has to say about these things. I don't want to get ahead of myself. Oh, well, here it is. Okay, so that was very short, and I'm happy because time is of the essence. Those are the main arguments. I talked to you about the Constitution. I talked to you about the how federal government is no longer funding enforcement of cannabis in these states. And then I talked to you about the primary argument, which is within the meaning of, like, why do we have an argument that cannabis does not, or 280 does not apply now ahead of rescheduling? Well, because there is some pretty good arguments that cannabis no longer fits the meaning of a Schedule 1 or Schedule 2 substance, and therefore 280E doesn't apply. Well, here's the IRS's response. Okay. And then, of course, you can see this again if you go visit that link right there. And this is interesting. The acting chief counsel is Kenneth J. Keyes. And I looked him up, And here he is. So Nathaniel Pollock's in our corner, and on the other corner, we have essentially a juggernaut. His name is Kenneth Keys, and he has been in federal government as the tax consultant for decades, since before 280E, which is crazy, which is a little scary. I don't know this for fact, but he may have actually been involved in actually writing the 280E, or at least he reviewed it to determine if it met congressional intent and whatnot. So it's a little scary, really, because this guy has been doing this for so long, and he actually went private for a little while, but then he's like, no, I want back in. I think he thought that going private would be less work. I actually heard from a colleague of mine who told me that he heard Kenneth Keys specifically say, and this is in the 80s, I think, that he thought he was going to work less in private practice, but instead he ended up working a lot more, and he ended up going back into federal work. Anyway, he is on their side. Okay. They responded to Nathaniel Pollock's brief with 4 rebuttals, essentially. And some of them directly address the arguments, and some of them kind of like take it into a little bit of a different direction. The first thing they say is that Nathaniel's interpretation of within the meaning is wrong, that it means classified as, period. And they hammer it over and over again. You can read it for yourself over and over again. He says it, that Congress meant classified, period. Okay. And then he was saying, well, we really can't do this because if we did this, if we said that cannabis didn't fit the meaning, it would improperly bypass the statutory and administrative structure, effectively creating a parallel system for classification outside of the CSA. So what they're saying is and then it's reiterated in the next number 3. And what essentially he's saying is you're asking us to conclude that cannabis shouldn't be a Schedule I substance. And he says that 280E, I'm really getting ahead of myself. I have slides for this. So let's see here. First of all, he says federal courts have addressed the applicability of Section 280E in over 40 published orders or opinions. No resulting order or opinion includes a ruling or holding that Section 280E is unconstitutional or inapplicable to cannabis sellers. And that is accurate. The tax courts have been deciding almost always in the favor of the IRS and the federal government in numerous court cases. And he states 40. And every one of them gets turned down. So I guess what he's saying is, well, if the courts have ruled against these taxpayers all these years, and then we should rule against them for this as well. It calls the argument that marijuana is not within the meaning of Schedule 1 or 3 meritless, and reinforces that marijuana remains a Schedule 1 drug until properly rescheduled, as phrased in Section 280E and based on the canon of the last antecedent. Oh, this is fun. So this is where he kind of gets into the semantics of the definition of within the, or what within the meaning means. He says, and this is fun, and you're going to have to read it yourself, I think, because it took me a long time to really understand what he was trying to say here. But essentially he says, as phrased in Section 280E and based on the canon of the last antecedent, the parenthetical within the meaning of Schedule 1 or 2 of the Controlled Substances Act directly interprets the preceding term. And in this case, it's the controlled substances within the meaning of a Schedule 1, Schedule 2 of the controlled substance. So what he's saying is that because within the meaning was previously the preceding term, then what within the meaning means is the definition of the Controlled Substances Act. Okay, not like the criteria of a Schedule 1 or Schedule 2 substance. So he's saying like defined by controlled substance. I don't get it. I don't quite understand. I don't understand where they're drawing that, but I think what they're saying is like just the canon of Controlled Substances Act, the classification system, the whole thing. It just means within the meaning of the whole Controlled Substances Act. And if cannabis is a Schedule 1 substance, then it's part, and that's what it is. It's the whole picture. We're not talking about the criteria of a Schedule 1 or Schedule 2 substance. We're just talking about the Controlled Substances Act, and cannabis is classified as a controlled substance. Okay, that's my interpretation of what they are trying to say here. Okay, so then he goes on to address Nathaniel's hypothesis that Congress meant to keep it over-inclusive in that if there's a substance that was scheduled as 3, 4, or 5, then they wanted to leave it open. So if it had the criteria of a Schedule 1 substance, 280E would apply, or a Schedule 2 substance, 280E would apply ahead of rescheduling, meaning like the DEA didn't have enough time to reschedule something and they want to punish somebody who's trafficking using 280E. Well, 280E is going to apply to that substance even if it hasn't been rescheduled, which would allow us to, of course, do that same thing. Like we're saying, well, 280 doesn't apply because it actually doesn't fit the criteria. So he's saying that they might be thinking, well, just because it's not a Schedule 1 substance, classified as Schedule 1 substance, then 280 still applies. The IRS rebuttals. A fatal problem with the petitioner's argument is that to be a controlled substance within the meaning of a Schedule 1 and Schedule 2 of the Controlled Substances Act does not merely mean to be identified under 813, the Controlled Substances Act. It also means to be controlled under the various schedules of the CSA. And so I can only think that what they're trying to say is that, well, A, it wouldn't apply to substances that aren't controlled, because that's what this is about, is the Controlled Substances Act, right? So it wouldn't apply to business. And I thought this at first, I kind of misinterpreted, I think, what Nathaniel was trying to say. I thought, oh, well, if there isn't a substance that had been already on the controlled substances list, 280E would apply. Because that happens. We come up with novel things all the time to get high. We love it. But Nathaniel was saying, okay, well, if it's on a schedule, what if it's on Schedule 3, 4, 5, and now it needs to be moved? Well, how did it get on 3, 4, 5? Did they mistakenly put it on there? I don't know, but that's the IRS's rebuttal, and it makes sense if the substance wasn't controlled, and then Nathaniel's argument wouldn't make sense. But what if they miscategorized a controlled substance? It's already controlled, but it needs to go on Schedule 1, but it was Schedule 3. Something like that. That's another of the IRS's rebuttal. Okay. Then the main thing that I think where the IRS is going is they're going to try to cop out. I think this is where the IRS is going. They're like, this isn't the place to decide whether or not cannabis is a Schedule 1 substance. So let's see here. Administrative authority and separation of powers. The IRS describes this as, okay, so the IRS argues the taxpayer is asking the task court to do something it is not permitted to do, independently determine whether marijuana belongs in a Schedule 1. The IRS describes this as asking the court to perform a de novo scheduling inquiry for marijuana, warning it would create a seismic rift between how substances are controlled and identified under the CSA and how they were applied under tax law. The tax court is not the correct venue to reschedule a controlled substance, and rescheduling of the controlled substance may only occur first within an administrative proceeding with the DEA, and ultimately as part of the rulemaking action by the DEA. And then tied to that, he talks about how their sister, he says specifically sister laws, like 280E was meant to be connected at the hip with Schedule 1 and Schedule 2. And to change that would tear those apart, and that's not what was meant. The CSA and Section 280 are sister statute and must not be read to conflict absent clear congressional intent. So I don't really feel like there's a lot, like, I feel like they kind of like are trying to go a different direction. They're like, hey, this is not the place to do this. And then finally, for Nathaniel's other arguments, no longer funding enforcement as well as the constitutional aspect of it. He replies, petitioners' remaining arguments regarding the scheduling of marijuana are irrelevant. Such a slap. Irrelevant. Bam, backhand. So anyway, I'm not going to go into why they're saying all of that. That's a big conversation all in of itself, but essentially there's court precedents. He's saying, well, just because the IRS stopped, or because the federal government stopped funding enforcement, doesn't mean they're legalizing it. Those are the main things. Okay. So I've presented those, and there's more. There's much, much more, but before I go into the next thing, when I read that response by the IRS, that was a very strong perspective by the IRS saying, no, 280E applies until it's rescheduled, and period. And that was more than we've gotten before. Like, we've gotten the IRS saying that in a bulletin, which is kind of like a strongly worded email. There was a guy who spoke at a cannabis conference for accountants, and he said, you're going to get audited if you do this. But that didn't mean that we didn't have reasonable basis. But now the IRS responding in that way and saying like meritless and the antecedent and the definition and all these things, scary to me, okay? But do we not have reasonable basis? What is reasonable basis? So if a position meets the reasonable basis standard, it meets the reasonable basis standard if it is supported by relevant authorities, such as the Internal Revenue Code, of course, regulation, case law, or IRS guidance. So that would be like substantial authority. A no 280 position, when based on a well-reasoned interpretation of statutory language currently under litigation, may meet this standard even if the IRS disagrees. So, because we're looking at statutory language of the IRS, okay, because the IRS does two things. It interprets the law when there's ambiguity, and it enforces the law, period, right? And so they are saying that when they say within the meaning, when we read within the meaning of, they're saying, well, that means classified as. That's their perspective. We are still basing our reasonable basis on the Internal Revenue Code, which is what the Congress wrote, okay? And then whether or not what Congress's intent actually was, nobody really knows, I mean, Kenneth might know because he was there, but who knows how involved he actually was in writing that. And again, Nathaniel writes some really good, arguments about how within the meaning is used in other areas of the tax code, how Congress uses listed in and listed on. They use listed in and listed on when pointing to actual lists, aka the Schedule 1, Schedule 2. So from my firm's perspective, we have reasonable basis, okay? And especially since this is in litigation. And therefore, a taxpayer does not have to pay tax on phantom income. Proactively pay tax on phantom income. Yeah, so we're going to revisit this again. But I wanted to touch on this after the going over the answering brief. But now I want to move on to another brief that was written in support of Nathaniel's New Mexico Top Organics. And it's what's called an amicus curiae, which means in Latin, apparently, friends of the court. So not only do we have Nathaniel in our corner, but we have other friends in our corner. And one of those friends is the folks at Holland and Hart LLP, specifically Jennifer Benda, who she may have taught here. I don't know. I've seen webinars of hers. I visited her. I had her on, we visited and did a little webinar, and she was very unhappy with me because I was pretty aggressive in my approaches, and tax attorneys tend to be a little conservative. They don't like to say anything. They just say, I don't know. But we as tax accountants have a different perspective because we're the ones freaking doing these tax returns, right? And we have to bump up against the IRS if we're going to bump up, So they wrote an amicus curiae, which is not a suit. It's just in support of New Mexico Top Organics. And look at the companies that are on here. So Colorado leads. So Jennifer Benda and team were representing Colorado leads et al. And et al. Means Massachusetts Cannabis Coalition, Inc., Nevada Cannabis Association, Inc., and the American Trade Association for Cannabis and something, Inc. And again, you can find this on dawson.usataxcourt.gov. This is really amazing. Like, I really, really like this. And it reminds me that, there's other companies, if you guys know other companies that want to be willing to contribute to go to court, one person just has to sue for a refund or something like that. You could take it to district court. There's many districts all across the United States. When I talked to Nathaniel last, he said, hey, what would be really helpful is there was other companies taking the same thing to court. And federal court is different than tax court. Tax court could probably cop out and say, hey, no, this isn't the place to debate whether or not cannabis is a Schedule I substance. But federal court is the place. Federal court would be the place to have that debate. And taxpayers who have been denied a refund can go to federal court. And I'll talk to you all about that. But let's get going on this. Okay, so Jennifer Benda, I just wanted to highlight her here. Has been a strong advocate of the cannabis industry for over a decade. And, and she's amazing. And I'm so glad to have her in our court. Okay, so she starts out super strong with this amicus curiae brief. A thorough review of the history of marijuana scheduling under the Controlled Substances Act causes one to question whether it is intellectually honest to believe that marijuana should have ever been listed on a Schedule I or II substance, which I love because isn't that the debate here? Is it intellectually honest that cannabis is a Schedule I substance? It's bonkers. It's bonkers that it is, and yet we have so many people in positions of power always reinforcing that it is, even though it clearly is not. Okay, so I'm going to try to burn through this, but they kill it in this brief, talking about the history of the Controlled Substances Act, the history of the scheduling, and all of the ammo, all of the times the court says cannabis is not a Schedule I substance. You really need to look at this. I don't think it meets your tests. I don't think it's highly dangerous or addictive. You need to look at this, okay? And always the courts defer to the court. You'll find that the courts defer to the DEA, and the DEA just gives them the finger every time. And at that time, the HHS also give, and even the FDA at one point gives them the finger. And the courts are just like, oh, I guess, we can't do anything about it. It's the federal government, right? So Congress created 5 schedules and initially placed marijuana in Schedule I, but not without reservation. It recounts that Congress acknowledged divided views. Opinions diverge widely. Representative Ryan said marijuana's effects were not comparable to other Schedule I drugs. The director of the National Institute of Mental Health stated that it has no potential for physical dependence. noting that the notion that marijuana is addictive is a fable and that marijuana does not cause physical addiction. Finally, the Department of Health and Education and Welfare, which is the precursor to the current Department of Health and Human Services, the HHS, recommended only a temporary Schedule I placement pending further study, and this is in quotes. And she used a lot of quotes from actual authorities, and again, you can see her brief by going there. But I'm outlining it really good because I thought every freaking thing that was said in there was so poignant and good. So in that same year, 1970, Richard Nixon puts together a commission headed by this Raymond Schaefer dude. And it was a 13-person commission which included 4 physicians, 4 members of Congress. The commission was charged with studying marijuana's pharmacology, its physiological and psychological effects, its relation to crime, and the effectiveness of the existing marijuana laws. So it's currently Schedule I substance, was supposed to be there temporarily. Nixon creates this Schaefer Commission is the name. And then they put out a report in March of 1972. It's right here. According to the brief, the Schaefer report, now known as the Schaefer report, Schaefer Commission conducted more than 50 projects, ranging from a study of the effects of marijuana on man to a field survey enforcement of the marijuana laws in 6 metropolitan jurisdictions. The commission overwhelmingly concluded that marijuana was no more dangerous than alcohol and far less dangerous than other Schedule I substances. The Schaefer Commission concluded marijuana does not cause physical dependence, poses relatively low public safety risks, has no proven record of causing a human overdose, not even one, and does not, and this is really important, does not justify Schedule I style criminal penalties. So this is what we're up against then. Like, we're complaining about money right now, but then people were going to prison for marijuana. And there's all sorts of other research you could do about like whether or not there was institutional racism involved in like targeting certain infringed group or marginalized groups and whatnot. I'll let you do that studying. But for right now, this is a literal commission, like a disinterested group of people who was, Richard Nixon put this together, right? So it's crazy that it did not get rescheduled at that time. So National Organization for Reform of Marijuana Laws, NORML, petition, this is May 18th, 1972, petitioned the Bureau of Narcotics and Dangerous Drugs, BNDD. BNDD is the precursor of the Drug Enforcement Administration, the DEA. So I might use, instead of saying BNDD, I might say DEA so that you guys know who we're talking about here. So NORML sued them and petitioned to remove, now it might not be a sue, it was a petition to reschedule the brief, so to remove marijuana from the Controlled Substances Act and to move it to Schedule 5, based on the Schaefer Commission, right? The brief says that the DEA swiftly and summarily rejected the position on the basis that rescheduling marijuana would violate U.S. treaty obligation under the Single Convention of Narcotics Drugs. So they totally are like, they came up with this and they're like, well, actually we can't now because it's part of this, this Narcotics Convention treaty. So then they sued, NORML sued in 1974. And then the DC Circuit Court rejected the agency's refusal to meaningfully consider the petition and remanded for a new look and hard look, emphasizing that Congress contemplated that classification set forth in the Act as originally passed would be subject to continuing review by the executive officials concerned, notably the DOJ and the HHS, the HEW. So they're like, no, this was meant to be temporary, and that was the court. The court concluded that in that lawsuit. The brief says that an administrative law judge, and so about a year later, almost 2 years later, an administrative law judge, an ALJ, found that, and a law judge is somebody who works for a federal agency. And they work for the DOJ or the DEA, but they're like supposed to be a disinterested like judge. They're involved, but they're not necessarily. It's kind of like the IRS's appeals division, right? The appeals division is not. They're employees of the Treasury Department, I think, but they're disinterested. They're like separate. They look at it separately. That's what the administrative law judge is. And they found that the treaty obligations could be met if the U.S. instituted controls over cannabis. So let's put it on Schedule 5 substance. Let's put some controls on it, put in a Schedule 5 substance. The ALJ recommended referral to the HHS for a formal review under 21 U.S.C. 811 recommendation, which is the CSA. But the HHS provided only a short 3-paragraph letter without the scientific and medical evaluation required. So they responded flippantly, essentially. They're like, here's the letter, get off my back. So that under that 21 USC 811 is the process that the DEA, the HHS and the DEA have to go through in order to start the rescheduling process. And essentially the HHS wrote a letter without the scientific and medical evaluation required. Oh man, we're okay. So then Normal sued again. The DC court rejected the DEA's attempt to avoid the CEA's formal scientific and medical review process and ordered the DEA and the HHS to follow the statutory process. So now the court ordered them to go look at that again. The brief says that HHS still recommended Schedule 1, even while acknowledging that no convincing evidence exists to suggest that abuse of a natural marijuana plant materially leads to severe psychological or physical dependence, and psychological dependence such as the types seen with opiate barbiturates or alcohol use has not been observed within the THC use in man. So the HHS concluded that it's not highly dangerous or highly addictive. The HHS justified its position by arguing that a lack of evidence of severe dependence favors placement in Schedule 1. If it should be established that these substances do not lead to severe dependence, then placement in Schedule 2 would be ruled out. No placement in Schedule 3 through 5 is possible unless the substances have a currently accepted medical use and treatment in the United States, which remained at that time disputed. So even though the Schaefer Commission did this whole thing, then they're still saying, well, there's no medical benefit. So Normal sues again. And then the DC court again admonished the DEA and ordered reconsideration, specifically directing the agency to take into account new evidence concerning medical use. So then, April 22nd, 1981, okay, the DEA refers the petition back to the HHS. This began another review cycle after the third lawsuit. In 1982, Congress enacts 280E. The brief notes that 280E was enacted during the same period while rescheduling dispute remained unresolved. June 29th, 1982, the FDA published a proposed recommendation to keep marijuana in Schedule 1, asserting that all 3 criteria were met. The brief characterizes the FDA's reasoning as circular. If the use of the drug is unlawful, whenever interstate commerce is involved, medical use of the drug cannot be classified as accepted. So it can't have accepted medical because it can't cross state lines, so it's not like it's illegal. So how could it have an accepted medical use? That's what their logic was. It used the same tactic to assert high potential for abuse, reasoning that widespread illegal use itself established an abuse potential. So because it's a Schedule 1 substance, it's highly abused. I mean, is that insane or what? The brief highlights a court case called, so in 2025, the brief highlights a court case called Fusen versus Office of Navajo and Hopi Indian Relocation, in which the court found that circular agency reasoning is not entitled to deference. So we shouldn't take it seriously. And we're going to get to the deference. Like, deference is something that's very, very important here. The brief, so in 1983, the brief explained that the FDA solicited comments and scheduled a public hearing. Neither the results of the hearing, the FDA's consideration of the comments, and the FDA's final recommendation to the HHS, nor the full text of the HHS recommendation to the DEA were published in the Federal Register. I mean, from my perspective, they're just screwing these people over, anybody related to the cannabis industry at that time. September 6, 1988, pursuant to the court's decision in the third normal court case, the DEA's administrative law judge, the ALJ, Francis L. Young, issued an opinion. Marijuana has a currently accepted, this is what he says, the DEA essentially is saying, the administrative law judge. Marijuana has a currently accepted medical use in treatment in the United States for nausea and vomiting resulting from chemotherapy treatment in some cancer patients. To conclude otherwise on this record would be unreasonable, arbitrary, and capricious, which I love that, arbitrary and capricious. Nearly all medicines have toxic potential lethal effects, but marijuana is not such a substance. Despite the long history of use and extraordinary high numbers of social smokers, there are simply no credible medical reports to suggest that consuming marijuana has caused a single death. By contrast, aspirin, a commonly used over-the-counter medicine, causes hundreds of deaths each year. So this is a law judge in the DEA that concluded that marijuana has currently accepted medical uses. Now that was September 6th, 1988. Simultaneously, 4 months before, in February 22nd, 1988, the DEA adopted a new 8-part medical test. The brief says that the DEA announced an 8-part test for currently acceptable medical use. The DEA uses an 8-part test to deny the normal petition and dismiss the ALJ's recommendation. So their own judge, they're like, forget you, you don't know what you're talking about. We're gonna use this 8-part test. Normal sues again. I'm gonna like go a little bit faster. Essentially, then the district court tells the DEA, you need to relook at your test. It's too, like, you can't pass, like nobody can pass that test. It makes no sense. One cannot logically show that a drug enjoys general availability or use by a substantial segment of medical practitioners if the drug remains Schedule 1. So how can it have accepted or how can it be enjoyed availability or have the availability if it's a Schedule 1 substance? Then the DEA replaced it with a 5-part test. Still, Normal objects, arguing that the DEA should reconsider whether a respectable minority of physicians accept the drug as Young ordered. So Young actually ordered that, but they're saying, well, most practitioners don't prescribe marijuana. So, but how can they prescribe it if it's a Schedule 1 substance? Okay, finally, Normal sues for the 5th time. This time, the DC court. Okay, so then the DC court allowed the DEA's 5-part test and stated under the Chevron doctrine. Okay, so now we're really getting somewhere here. And I'm so sorry that it took so long, but I feel pretty passionate about this. Like, I feel like they do such a fabulous job just showing how the cannabis industry has bent over all of these years. And it's so sad to think that people have been serving like life sentences for this. You know what I mean? So, okay, the Chevron doctrine. This is really important now, guys. I know I put you to sleep for a second, but let's talk about the Chevron doctrine and its demise. So there was a court case. It went to the Supreme Court, and ultimately the court ordered that the federal government has deference, essentially. The Chevron deference, that's what it's called. And what that Supreme Court case did was say that, okay, the courts have to defer to the federal agencies. And that's essentially what was going on for these decades, even though the Chevron deference went into play in 1984. The injustices were happening before that. But ultimately, after a while, the courts are like, you know what? I'm tired of hearing your whining, Normal, and cannabis industry. There's nothing we can do. Obviously, we keep deferring to the federal government and they don't respond like in the way we're telling them. So I'm sorry, there's nothing we can do. But in 2024, Loper Bright Enterprises versus Raimondo, the Supreme Court officially overturned the Chevron deference, stripping agencies of their automatic legal advantage. Judges must now use independent judgment rather than deferring to agency expertise. For cannabis, this creates a far stricter judicial scrutiny of the DEA scheduling decisions and a fundamentally fairer playing field. So, you know, things have changed, right? You know, in California was first with the 215 Act. They legalized medical marijuana in 1996. There's 40 states by 2016 that have either a low THC or decriminalized legal framework or medical a medical program. 202 million patients served, but still the DEA has denied 4 petitions to reschedule 4 times up to 2016. Okay, so and then the United States versus Green, the district court recognized marijuana was currently being used for medical purposes and stated there would be no rational basis to conclude otherwise. Sisley versus the DEA, even though so what happened here was the plaintiff didn't go through all of the administrative proceedings to get this court going, so it got thrown out, but the judge highlighted the strength of the petitioner's arguments that the DEA's conclusion was an erroneous interpretation of the CSA. Then we've got, of course, the HHS recommendation to reschedule. This is fun, impermissibly narrow. So the DOJ had to go, they went with their Office of Legal Counsel, went and reevaluated the DEA's, I think it was 5-part test, right? To determine whether or not cannabis was could even meet the definition, or they were revisiting whether or not cannabis was actually properly scheduled. And the DOJ, Office of Legal Counsel, found that the 5-part test was impermissibly narrow. They couldn't pass. The cannabis industry couldn't. The cannabis couldn't get off of Schedule 1 substance based on this 5-part test. Here's the statutory language. The recommendation of the HHS Secretary of Attorney General shall be binding. Okay, and this is important. In the CSA, it says that the recommendation of the HHS Secretary to the Attorney General shall be binding on the Attorney General as such scientific and medical matters. And if the HHS Secretary recommends that a drug not be controlled, the Attorney General shall not control it. So here we are in a much different place now. Can the tax courts cop out? Can they say, well, the tax court is not the place to determine whether or not cannabis is a Schedule 1 substance? Or can they and should they? Because they're required to. The tax court is required to decide what is the most applicable language that's out there. Who has the authority? Okay. So assuming they don't cop out and say, hey, no, what Congress meant is that 280E within the meaning means classified. If they look at it and they're like, okay, maybe they meant that. And then they look at all of this law, all of these lawsuits, and realize that the DEA has been arbitrary and capricious all these years. The tax court does have the authority to say, you know what, I think 280E doesn't apply here based on that. All right, you guys, thank you for riding along with me on that journey. That was pretty, I had not actually made it all through my presentation. So you guys, I hope you guys aren't asleep. Okay, so let's talk about reasonable basis again. Now that you know that we're talking about the Chevron deference being overturned, now that you know about the HHS, now you know about all of the arguments that there are about what do we mean by within the meaning. Now you know how the DEA has been arbitrary and capricious all these years. Do we have basis for not proactively paying tax on phantom income? Or is it frivolous? I don't think it's frivolous. I don't think it's a frivolous position. And my firm has been going forward with this for a few years now. And so far we haven't had a lot of pushback. We may get some now because because I'm out there telling you guys about this, but I'm hoping that you guys get on board. I think it just is the right thing to do. It's the right thing to advocate for your clients. Not merely doing tax returns for the cannabis industry is not necessarily doing them a favor. If you bury your clients in tax debt because you don't want to implement any tax mitigation methods or strategies, then you're actually doing them a disservice. Bare minimum, you need to know 471C. Bare minimum, you should be implementing that to the fullest degree that the tax law allows, which is pretty significant if you actually read it. Let alone like, hey, giving them the option. Do you want to potentially fight this fight? Like, right now the IRS is underfunded. We have a reasonable basis. Reasonable basis means that, yeah, they might try, the IRS might try to put some penalties on you for filing a frivolous tax return. But I think appeals would probably argue that, no, this isn't frivolous. Compared to the other court cases that have been out there, and even the tax courts have forgiven debt or penalties and whatnot, just from the fact that, hey, you had somewhat of a reasonable argument, you were represented by a decent professional, you had some good books and records, so no penalties for you. That actually happened quite a bit in those other court cases. Okay. So these are the questions that we get asked a lot. Is there a chance of audit, and is the petition defensible? Our perspective is that yes. Again, we have a reasonable basis. You only need a 20 to 30% likelihood of success. I think that the IRS may cop out. They may say this is not the place to have this debate as to whether or not the DEA was arbitrary and capricious and cannabis doesn't fit the meaning of the Schedule 1. We're going to conclude that 280E applies. So that could happen, and it might likely happen. But then there's an appeals process, and that will go straight to the district court system, where it actually does matter whether or not cannabis is actually meet the criteria of the Schedule 1 or Schedule 2 substance. That brief by Holland and Hart Group, I bet would do wonders in a situation like that. So if you know anybody who might want to take that to court, let us know, hire them, whatever. Like we need people to fight this fight. The IRS Cannabis Task Force and erroneous refunds. Okay, so we have heard that when you try to amend a return, so we've been amending returns and some things have been happening. We have been getting some denials, meaning the IRS, so no audits, but the IRS is like, no, denied. They disagree. They're like, you know what, 280 applies, period. We're not going to process your amended return. That's ridiculous. And so then they get what's called a denial. And some of them I heard out in like the Michigan area, the processing unit is also applying penalties. Now, I don't know if it's because they weren't doing the amendment right. They weren't putting in the 8275. They weren't like disclosing why they were trying to amend. I mean, that's important to do that. So in this slide here, we talk about Form 8275 disclosure statements. Clear identification of cannabis as the business activity. Make sure that you say that it's retail cannabis on the tax return. Explicit reference to 280E, you're talking about 280E. A multi-page legal explanation of position. So you can take these briefs and you can distill them down. You can say like, hey, this is what's being argued right now. This is based on the statutory language of 280E. And these are what we're interpreting within the meaning means, okay? And this is currently in litigation. So until that litigation concludes, which might be 4 years from now or something like that, you have a reasonable basis to not proactively pay tax on phantom income, but you want to put in an 8275 with the amended return to make sure that you're fully disclosing your position, okay? And it's almost like a legal position, okay? We're not attorneys, but you can get pretty close because you're smart people. Let's see, what disclosures do you include with the returns using these positions? Oh, I already said this, Form 8275. Form 8275 is if you're not debating the code. 8275R disclosure for positions contrary to the IRS regulation. That one is more for 471C because I don't know if you guys remember, a lot of you are using 471C for the first time, and you may not remember that the IRS put regulation down on 471C like a wet blanket back in 2021. And they said, no, you can't. If expense is otherwise disallowed by another code section, i.e. 280E, then you can't use this. They said that in this regulation, which meant they were talking to us. I mean, that's what they were doing. They were talking to us. But we were like, you know what? There's no merit in that. Like that, nothing in 471 says that we can't use 471 to the degree that 471 says we can use it. So we're going to use it anyway. Well, we would file 8275R telling them that, like, hey, we know about this regulation. We don't agree with it. And we're going to move forward with using 471C the way we've been using it because, you know, it's the law and they don't write the law. Okay. 8275R, I think, would be the one that you would write your three-page legal write-up about, you know, within the meaning and all that stuff. You include the deducted amounts. You tell them, like, hey, this is the amount that I'm disputing. You make sure your business activity is on there. You don't say things like retail, you know, sales or something. You don't try to cop out and not tell the IRS what you're doing. Okay. Does IRC 471C apply to cannabis businesses? Again, I'm getting ahead of myself. Like, we've been using 471C for years, and it has worked marvelously for years for our clients, and it still works. Now, something that's happening out there that people are doing, they ought not be doing, or they're not supposed to be doing, but you probably slide by, is that they're amending and using 471C. Well, 471C is an accounting methodology or an inventory accounting methodology. So if you recall, many of you know this, but some of you may not know this, in order to change your accounting method, you have to file a timely filed return, form 3115 with a timely filed tax return. Okay, so you can elect to use 471C now and going forward, with a timely filed 3115, or if they're new, they're brand new and they haven't filed, then you can elect that 471C methodology. Going back if they have not filed a return. But if they have filed a return and they just put cost in their inventory and you're now using a 471C, you have to do a 3115, and you should do a 8275R because it actually is. You're not allowed to use it according to regulation. All right. Let's keep going. We're almost done. If you file an 8275R, does that increase your chance of being audited? Isn't that fun? Like, I heard this for years, that the R, that's attached to 8275R means request for an audit. Fortunately for us, that is not the case. We've never had that disputed in an audit. Like, they've never audited us, and we've been doing this for like 10 years. Well, we've been using the 8275R since 2021. Okay, so so there's still time, but for 2021, 2022, 2023, 2022 statutes are running out, and so far so good on not having audits that were a result of the 8275R. But really, you should consider using them. Don't try to go under the radar, by actually filing a frivolous amendment or tax return and not including these disclosures when you're moving forward without reducing deductions. You need to be very, very transparent on what you're doing to fully protect your client. Audits. So far, no audits. I've been doing like these cannabis returns. I've been niching in the cannabis industry for over 10 years. And we have not had a single audit based on these positions here so far. I have had a couple audits. There were random audits. One was a partnership holding company under the decentralized partnership audit regime. Have you guys had one of those audits yet? They're insane. The IRS agent didn't know what the hell was going on. They're like, this is insane. It was too small of a partnership for as much work that she had to put in. She was like, let's get this done. And they settled for a payment, and then she was on her merry way. And that was nice. Okay, so the IRS denies an amended return. So what happens when we amend returns? Okay, so we have a pretty good result so far. We have been amending these returns. We've been getting mixed results. They've been strange. We'll do like 12 amended returns, three, so maybe over 4 different businesses. 3 will get refunds, okay? 3 will get denials, and then 6 of them are still pending because it's taking the IRS like 13 months to amend any or to allow the amendments to go through. Their processing time is awful right now. In fact, they just put out an announcement saying, hey, that the IRS is taking on average 13 months to process these amended returns. I'm noticing that when we ask for refunds, like when you want the IRS to write a check, those get scrutinized a little bit more, and those denials come a little bit more frequently. If you're asking them to reduce your liabilities, they have been a little bit more generous. Other than that, I haven't figured out any rhyme or reason, because there's different processing units all over the United States, and I'm noticing that they're coming in willy-nilly. Like some of them come in really fast, some of them take a long time. But they're still coming in. Some people are getting their money back. Most are being able to reduce their tax liabilities. I think the IRS actually likes that. Like, hey, like these guys aren't going to be able to pay anyway, so like maybe why don't we just give them a break here and reduce their liabilities so we know exactly what they actually do owe, instead of like trying to chase after what they owed plus the phantom income, you know. So if it gets denied, there's 2 year. You can do both. They're not exclusively mutual or mutually exclusive. You can request an appeal, which you maybe ought to do. You have 2 years to then, if the appeals officer, if you can't settle in appeals or that's not going well, you can take it to tax court. Nobody likes that idea though, right? That's expensive. If there are people who want to take it to tax court, please, like, let's do it. Let's pull some money, let's make it happen. But it could be that the appeals office is so busy they don't do anything, and then you lose your refund. So there is what we've been starting to doing is immediately sending off a 907 and requesting more time until this court case gets resolved, which could take time. So you can ask for extension, just like the IRS. The IRS will ask you to extend the statutes when they audit you. You can ask them to extend the statutes to take it to court. And I know the appeals office is so busy that what we've started to do is just be like, hey, appeals, can you just sign this? Then you don't have to deal with it for a while, right? And then it might resolve itself, because we're going to find out what happens with this tax court case. But the timeline that you have is once you get the denial, which could take a year or more, then you have 2 years. You can request the appeal immediately, but if they don't get to you, you need to get that extension of time. Otherwise, you have to take it to tax court, or you lose your ability to get that refund. So that's my point, though. But ultimately, you're not penalized. You're back to where you were, right? You're out some accounting costs, right? Because you're going to charge for this, and they're going to be out some accounting costs. We've got still pending. We've got about a 65 to 70 accepted rate. Like, so all the amendments that have been accepted, about 30% of them have been denied. So it's no fun, but it doesn't mean they're out the refund. We just have to go through this really long and arduous process. It doesn't take a lot of time though. It's just something that you have to stay on. We have a whole amendment sheet, we're tracking everybody. Statute of limitations, beware right now that 2022 is expiring. Okay. So, so if your client's returns were filed by the deadline, you're probably out of time to amend those 2022 returns. But if they were extended, then you have until the filing date to amend those 2022 returns. There's a 6-year, of course it can be audited at 6 years. Let's see here. You have time for original returns. Anyway, I think I'm out of breath right now. Why don't we do some Q&A? We got 10 minutes. Okay, so I guess I'm all right. I'm looking at these. Hello from Florida. Interest in the topic. CPE for CFE. Okay, cool. Hello, I'm Maria. I'm here to learn more about IRS. Let's see. Answered priority. No priority questions. I think you guys are probably working at your desks and you're tired. I think you guys, if you guys on the East Coast, it's like after 5, you'll probably come and watch this again. But yeah, so I don't see any questions. There's a lot. You guys can always reach out to me and ask some questions. Reply to your. Hopefully, you guys reply favorably to the response. All right. Thank you so much. Okay.
Justin, hey, I'm here. I'm here. No, I'm listening. No, Justin, I just want to say thank you so much. Really appreciate you being here. Oh, and look at that. Taylor just typed in. It's like, where can you learn more? Now they're typing in.
I don't know anymore, man. I think going to the briefs themselves and reading more about the briefs. Otherwise, we're like watching it like a hawk. That's because it means so much to my clients that we're watching it very, very closely. And so you could always you could go to my website. We have a newsletter, and I'll probably share a link to this video. Yeah. So let's see. Are there any other questions?
No, everybody's saying that they appreciate
9 more minutes.
Topic. So Justin,
they're ready to go to bed or get back to work.
No, everybody's saying it's an interesting topic and they appreciate the course and they're saying thank you. So Justin, we can close this up. Justin, thank you so much for presenting today. Really appreciate it. Really appreciate how thorough you were. Very interesting content. People keep typing in. So really cool.
Yeah, topic. It's a lot. It's a lot of information. But it's time. You know what I mean? It's time that we put this 280E thing to bed. And there's more. I have more opinions, but that's another 3-hour conversation. So, right on.
Well, thanks again for presenting to our audience. Thank you so much for attending. We'll do our best to get your credit processed a little later today, but you should see that in your account by tomorrow. And we did record this session. We'll make that archive link available to you as well. Thanks so much, everyone. Have a great rest of your day.